And Tracy, I saw you were online. Are you still ready to go?
I'm ready whenever you are.
Awesome, thank you. Okay, it is 1:30. Let's come to order and go on the record. Good morning, all. Or I'm sorry, good afternoon. My name is Charles Hatcher, and I am the regulatory law judge presiding over this on the record presentation. Today is August 25th, 2021. The commission set this day for an evidentiary hearing in file number GR-2021-0108. Due to the COVID-19 pandemic, we are meeting virtually in WebEx telephone and video conference. We are also streaming the audio of this hearing over the internet on the commission's website. A couple of quick website or WebEx announcements. Everyone, please mute yourselves. That's going to allow for less background noise that we were just hearing. We are going to proceed slowly at every step, and that is going to allow for the unmuting that I just mentioned. Also, a warning on WebEx chat functions. Those are not private. Those are not part of the record, but other parties may be able to see whatever you're typing into the chat. Also, if you are on the phone, please press *6 to unmute. I'd like to note for the record, we have the attendance of Commission Chairman Sylvie and also Commissioner Poolsman. I believe, I see Commissioner Kolkmeyer, and I believe Commissioner Roop and Commissioner Coleman are on the call-in lines. Let's go ahead and get started with our entries of appearance. Spire, would you please start us off?
Good afternoon, Judge. Appearing on behalf of Spire, Missouri is Goldie Boxstruck, Matt Applington, and Rachel Niemeyer. Our address is 700 Market Street, St. Louis, Missouri, 63101.
Thank you. And for commission staff?
Good afternoon, Judge. I apologize for my label. This is not Jim Bush. This is Jamie Myers. So Jamie Myers appearing on behalf of staff. Also with me is appearing Kevin Thompson and Curtis Stokes, also on behalf of staff. Our contact information has already been provided on the record in this case file.
Excellent, thank you. And Office of the Public Counsel?
Good afternoon, Your Honor. John Kleiser appearing on behalf of the Missouri Office of the Public Counsel. My contact information has already been provided on the record in this case.
Thank you. And we will go through the list of interveners. They were not required to be here today, but they were invited. Midwest Energy Consumers Group.
Good afternoon, sir. David Woodsmall on behalf of MECG.
Thank you. And Consumers Council of Missouri. And Missouri Industrial Energy Consumers.
Diana Plesha on behalf of the MIEC.
Thank you. National Housing Trust.
Thank you, Judge. This is Andrew Linares on behalf of the National Housing Trust.
And for Renew Missouri.
Good afternoon, Judge. This is Tim Opitz on behalf of Renew Missouri.
And Legal Services of Eastern Missouri.
Good afternoon, Judge. Paul Bars on behalf of Legal Services.
And Missouri School Boards Association.
Richard Brownlee. With me, I believe, is also Louis Irwin Sr. and Louis Irwin II. And my address for my law firm is on record numerous times at the commission.
Thank you very much. And for Vicinity Energy.
Good afternoon, Judge. Appearing on behalf of Vicinity Energy, this is Lewis Mills with the law firm of Brian Cave, Leighton Paisner. My address is 221 Bolivar Street, Jefferson City, Missouri, 65101.
Thank you very much, everyone. We are here to address the 4 stipulations that have been filed in this case. My intention is to go through each stipulation by date. Is that also the party's intentions? We'll just maybe get into opening statements. We'll call on Spire first. Spire, if you'd like to give your opening presentation.
Sure. So I was thinking we would give a separate one for each stipulation, Judge.
That sounds perfect.
Okay. Generally speaking, the 4 stipulations represent a resolution of a significant number of rate case issues by the case parties. While these were the stipulations that were reached, the company would have liked to have resolved even more issues and remains open to further discussion and resolution of the outstanding issues in this case. Regarding the school transportation program stipulation and agreement that was entered on July 23rd, 2021, I believe that the school board has asked to go first in making a statement. So I will reserve till after the school board has given theirs.
That sounds very understandable. Mr. Brownlee.
Can you hear me?
Yes, sir.
Okay. Thanks so much. What I intend to do is really try to replicate what I did at the opening comments when we were on the record, and I'm going to go ahead and proceed. The Missouri School Boards Association has intervened in both of these cases, as well as almost every other gas utility case that's been filed since the year 2002. We are a 501c6 not-for-profit corporation. We represent about 380 Missouri school districts, which are over 2,000 individual school facilities. In 2002, through a bill at the Missouri legislature, of which I believe at the time both Commissioner Roop and I believe Commissioner Coleman were actually in the legislature then, we passed a bill which really created a school transportation program, an STP program at section 393-310. And this allowed the schools to go together to create a natural gas purchasing group. That is, we sort of, by the joining together, we were able to appear as like a large corporation or a large gas purchaser. We were able to purchase gas off the open market. We transported it in through the interstate pipelines, and we delivered it to the actual local gas utility. And it was really through a not-for-profit school association. The statute had about 2 or 3 different factors. I'll quickly try to go through them. The utilities were able to sell the natural gas and the interstate transportation capacity. It was at the utilities' cost of purchase for both gas and transportation, plus they got to cover their distribution costs, plus aggregation and balancing, and all that was determined by the commission. There was no requirement in the statute for any expensive telemetry or daily metering. And finally, the school aggregation tariff could have no financial impact on the utilities, the other customers, or local taxing authorities. That, again, was in 2002. We have been working in a number of cases with the intent to try to get to some sort of a standard or uniform tariff application where all the schools would be treated similarly in all of the gas utilities. And in this particular case, the proposed school transportation program, STP tariff, It was going to be the same for both Spire East and Spire West. And then I'm going to read something because it's best written shortly, but it created a capacity release quantity for summer and winter periods based on maximum daily use during the recent rolling 7 years. It was adjusted for school account addition and drops, plus a 10% safety margin. And in addition, there was an allowance for to use the new Spire St. Louis pipeline, which gave us an alternative to the only other source in St. Louis, which was through MRT, Mississippi River Transmission. And finally, the capacity price at Spire's cost to conform would all conform to the original statute going back to 2002. We were able, in this case, as we have actually in several other recent gas cases, we've entered into a non-unanimous stipulation. I think all the parties on the call today have been involved either directly or indirectly in those other cases. In this case, I want to reach out to quickly the staff and public counsel, and particularly the company for being cooperative and understanding that if we can get to a resolution, it'll be a huge financial burden off of all the schools not to have to hopefully participate in these gas cases because they're expensive and the schools have no way of adjusting income or outgo to facilitate full participation. So this is really it's a great deal for the kids, it's a great deal for the schools, and I think it's a great deal for the commission and the regulatory process. I don't have anything addition. We do have engineering experts who have been from the very beginning, Louis Irwin. They're with Energy Advisors, a company that does this work in a number of other states. And if we'd stand for questions after Spire gives a little speech, I think they'd be much more competent to answer any questions the commission or the ALJ might have. And that would be about the best I can do on this.
Thank you, Mr. Brownlee. Back to you, Ms. Bogstruck.
Thank you. May it please the commission. Mr. Brownlee actually covered a lot of the points that I had intended on covering, so I will be very brief. The Spire, Missouri, the Missouri School Board Association, and staff have agreed, as set forth in the July 23rd, 2021 non-unanimous stipulation and agreement, to a modified school transportation program tariff that represents improvement to the company's current transportation capacity provisions.
I'm sorry, you cut out there. These call-in users, I think, are cutting you out, but I got transportation program tariff that represents.
Sure. An improvement to the company's current school transportation capacity provisions. These changes support the schools in obtaining both affordable and adequate gas service.
Ms. Bogstruck. Ms. Bogstruck, can you hear me? Okay. I just went through and muted a bunch of the call-in users. Would you press *6, or if you're on the app, if you could try and unmute yourself?
Can you hear us?
Yes.
Okay. Hopefully that takes care of that.
Yes, perfect.
So I pretty much finished my statement. I was just going to say that the company has available Lou Keithley and Scott Weitzel here today for any questions the commission may have on the tariff changes.
Thank you very much, Ms. Bogstruck. Are there any other parties that wish to speak on the July 23rd stipulation and settlement? Ms. Myers?
Yes, Judge. So I think as staff, we had planned to give very general comments on all of these stipend agreements. So would you prefer that we wait until the end to give a general comment, or would you prefer for us to do that now?
I anticipate that we can probably take your staff statement up after we conclude with the July 23rd stipulation, as it really involves a fairly narrow issue.
Would be fine. Thank you.
Okay. Are there any other parties that would like to give a presentation on the July 23rd stipulation? This is the school transportation issues. Okay, and I'll ask, are there any commissioner questions on the July 23rd stipulation? We'll give a moment for unmuting. And I don't have any questions, so we'll move on to the July 30th stipulation. And again, we'll start with Spire.
Judge, can we be excused? Is there a protocol on that I missed?
No, Mr. Brownlee, thank you very much for being here. It appears that we don't have any questions for you, so you are excused. Thank you.
Thank you so much. Appreciate everybody's help.
Absolutely. Thank you, Mr. Brownlee. Ms. Bachstruck.
All right, may it please the Commission. The July 30th, 2021 partial stipulation and agreement represents the resolution of approximately 45 rate case issues. This agreement was the product of many discussions and collaboration amongst the 8 signatories. The company appreciates everyone's work in the resolution of these issues. The resolution of certain revenue-related items has resulted in a black box settlement of an increase to the company's revenue requirement of $587,904, specific to items such as dues and donations, bad debt, and injuries and damages. There are other agreed-upon items that represent further steps by the company as One Spire, Missouri, including a uniform measurement of CCF billing for all of its customers and a consolidated tariff book. The company hopes that the Commission will agree that the manner in which these issues have been resolved are in the best interest of our customers. We have numerous witnesses available here to answer any questions the Commission may have that are specific to this agreement. Thank you.
Thank you, Ms. Bachstruck. I think now, Ms. Myers.
Thank you, Judge. This is Jamie Myers on behalf of staff. Just generally, staff was a signatory to each of these 4 stipulations and agreements. It is staff's position that, again, each of these documents was entered into after extensive negotiations. Staff believes that they are reasonable resolutions of the issues that are contained therein. I know that there was a question posed regarding, does this resolve all the issues in the case? From our perspective, from staff's perspective, it resolves all contested issues except for, and now these would be non-contested issues, the 9 issues that were heard at the evidentiary hearing, August 2nd through August 6th, as well as 2 tariff issues that have been filed in this case file. And with that, I will say, in addition to myself, we do have Kevin Thompson and Curtis Stokes appearing on behalf of staff, and we do have some technical staff with us if there are questions that are of a technical nature. Thank you.
Excellent. Thank you, Counselor. This was our largest, I have been referring to it as the omnibus settlement, the July 30th settlement. Let's see if any other parties wish to make a presentation before I move to Commissioner questions. Any counsel for any of the interveners or Office of the Public Counsel? Okay, we will move to Commissioner questions. And again, it is *6. We do have all of the commissioners online. Are there any commissioner questions on the July 30th stipulation? Okay, I'm not hearing any. I do have several questions. and I'll go ahead and go over that. Ms. Myers, you spoke kind of about the issues, making sure they were all addressed. And this is not specifically for you, but to explain to everyone, what I did was I looked through the original list of issues that was presented, I think, July 22nd. And then I compared that with each of the four stipulations. I found two areas to note. I just want to confirm on the record, lobbying, issue 4, it is listed in paragraph 2 of the July 30th stipulation, but it's not further described there. I am looking for confirmation. I would guess from Spire. It was previously removed. My understanding is it was covered in the Spire position statement and in Mr. Weitzel's rebuttal on revenue requirement, and that's Exhibit 41, and I'm referencing page 12. Inspire confirmed that they have withdrawn or not submitted issue 4 on lobbying.
Your Honor, this is Matt Applington on behalf of the company. I believe that the intention was for lobbying expense to be treated as part of the black box agreed rate items in paragraph 5 of the stipulation. That's on page 3. I think we had sort of lumped that in together with dues and donations, but in any event, it should be part of the black box agreed rate items.
Okay, thank you. The other discrepancy is on issue 45, subparagraph G. The original issue regards tariff sheet R-25 relating to the usage estimating procedure. Paragraph 20 of the July 30th stipulation says it is regarding tariff sheet R-13. And that one addresses company inspection of customer premises. I would note that the very next paragraph in the stipulation says anything proposed that is not approved specifically is hereby rejected. So my question is, the original issue 45G regarding tariff sheet R-25, what is the final disposition?
Your Honor, this is Kurt Stokes. And
yes,
if you look at the same page 8 of the July 30th stipulation, paragraph F states that the signatories agree that there will be no changes to this section of the company's rules and regulations, specifically sheet R-25.
Oh,
does that resolve your question?
Yes, it does, but I'm not finding where you're looking at. I'm on page 8.
Page 8, paragraph F on usage estimating procedure. The first full paragraph there.
Yep, I found it. Thank you very much.
Oh, absolutely, yeah.
Next, I want to move to COVID-19 AAO. This was issue, I don't have the issue number here. It's in paragraph 3 of the stipulation. My question, of the 6.2 million, that's the stipulated amount, and I'm rounding. Of the 6.2 million stipulated amount to be amortized over 5 years, can you quantify the amount specific to Spire East and Spire West? And I'll open that up to anyone that knows.
Judge, this is Scott Weitzel, Aspire. I believe, I could check with staff, but I believe that we could do that if needed.
And Judge, that's true. We could do that, provide that information. It would just take us a short amount of time, probably a few minutes.
Okay.
So if you'd like to come back to that, we could provide that.
Perfect. My next question on COVID, and my only other question on COVID, is what amount will be included in rates for East and West? what amounts would be included in
Okay.
rates.
So staff is writing this. We're going to look that up as well.
Perfect, thank you. I'll move on to propane storage. And to give everyone a sense of where we're at, this is my third of 6 issues I want to touch on. And it's the third of 4 for the July 30th stipulation. Propane storage in the stipulation, this is paragraph 28. What is the value of the propane storage depreciation expense and rate base that will be included in rates under the stipulation? What is the value of the propane storage depreciation expense?
Judge, this is Scott with Spire. We would need some time to track that down for you.
Okay.
And Judge, can you repeat your second question, minus depreciation expense, the value of depreciation expense?
Well, what is the value of the propane storage depreciation expense and rate base that will be included in rates under the stipulation? Also on propane storage, does that value number include the $10.7 million rate base addition for propane inventory? Is the propane included in inventory still available as of May 31st, 2021 for use by Spire? I'm going to read the next 2 questions, but I think what I'm going to end up doing is issuing an order asking for responses to give the company a little time. My next 2 questions on propane storage is the Appendix A, page 2 of 4, LP total revenues of $12,417, the normalized revenues from propane sales. If not, what amount of propane sales revenues are included in Spire's cost of service? And 4th question, Spire witness Robert Nolker stated in his rebuttal testimony that the propane assets are no longer used and useful. So why would it be appropriate to include the propane assets in rate base and the depreciation expense in rates? Like I said, I am willing to move on to my next issue. It sounds like Spire would like a few days, some time to respond to that. Okay.
Judge, that's very helpful and a good recommendation of issuing an order just to check those handful of questions for you. Perfect. And the commission.
We can do that. Let's move on. My 4th and last issue for the July 30th stipulation, AMI opt-out. This is paragraph 29 in the stipulation. And I'm going to read from that paragraph. It states, Spire's rules and regulations, quote, adjustment for heat content, end quote, will be renamed to, quote, automated meter reading opt-out, end quote. Would you please clarify if the existing, quote, adjustment for heat content, end quote, will be, and here's my question, will it be renamed or replaced with the automated meter reading opt-out proposed tariff?
Hello, Judge. This is Scott Weitzel with Spire. This will be removed since we're going from therms to CCF for all of Spire, Missouri. It's replacing that with the opt-out. So okay. There will no longer be an adjustment for heat content in our tariffs or rules and regs.
I see. Okay, excellent. Thank you. The draft rule, and I'm still talking about the draft automated meter reading opt-out rule. Language states, quote, customers receiving residential gas service have the option of refusing the installation of remotely read metering or requesting the removal of previously installed remotely read metering. In Mr. Risky's testimony during the evidentiary hearing, and that is August 3rd, so Monday around the 1 hour and 36-minute mark, and also the 1 hour and 40-minute mark, he stated the following. All residential diaphragm meters in Spire West have a device attached that allows them to be read by a van driving by. Ultrasonic meters in the West, currently functioning as AMR meters, are also read in the same manner as diaphragm meters, which is by a van that drives by. Residential diaphragm meters in East, which have an attached AMR device, are currently read by a fixed network, which transmits meter readings through the network without the need for a van to drive by. We heard about that testimony with the satellites, or I'm sorry, the antennas. Ultrasonic meters added to the East will be read by a van that drives by, similar to all of the meters in the West. Sorry for the long setup. Here's the questions. How are the terms, quote, remote reading, end quote, or, quote, remotely read, end quote, that were used in the draft rule, how were those terms defined? Remote reading and remotely read.
Judge, I believe that that is intended to apply to all of the situations that you've described where meters are read other than by a person physically standing at the meter reading the dials. So that would apply to all of the different fixed network and van read scenarios. This is really intended for someone who does not want any kind of transmitting device on their meter to have an option to have a technician physically come to their house and just read the dials and record that measurement.
So the intent.
I'm sorry, I don't know who that was speaking.
Mr. Applington.
Sorry, that was my fault. Matt Applington.
Will the $30 per month charge only apply to meters that are manually read? In other words, an employee that has to go to the meter to read the meter?
That's correct, Judge.
Okay. If a customer opt out of the new ultrasonic meters and if a customer opts out of the new ultrasonic meter and wants to keep their existing meter, if the existing meter is a diaphragm meter with that AMR device, would this customer be charged $30 per month?
Yes, the $30 charge is really intended to compensate the company for time to send a technician to manually read a meter, whether that's a diaphragm or an ultrasonic. I think that's not really the distinction. It's more about whether the device is actually going to send reads or have reads be collected versus someone physically there at the premises.
I think the question is maybe a little simpler than what we're thinking. The customer opts out of the new meter, wants to keep their existing meter, which would still be read by the van driving by. Would that customer get the $30 charge? So they've refused the new meter, but they're still on they have the attachment for the AMR.
I'm tracking you now, Judge. No, they would not be charged.
Okay. In Spire, Missouri East, where the diaphragm meters with AMR devices are read on a fixed network, and the new ultrasonic meters installed as of June 29th, 2021, will be read by a van. Do both of those constitute being remotely read?
Yes, they do.
Last question. Does the stipulation include the suggestion from staff in Claire Eubank's rebuttal testimony, page 3, lines 1 through 11? Does the stipulation include Ms. Eubank's suggestion recommending that the $100 meter setup charge only apply in situations where the company has incurred additional expense related to the customer's decision to opt out of the standard meter?
Yes, Judge, this is Matt Appleton again. I think that's the intention here, is that the $100 is for to reimburse the company for a trip to go out to change the metering equipment. So if, for example, a customer built a new house and communicated to us on the front end that they wanted to opt out of certain metering equipment, there would not be any additional cost. You know, it would still just be one trip, so the $100 setup would not apply. That's only to reimburse for a second trip, which is, I think, the point of her suggestion.
And Judge, from staff's perspective, I agree with Mr. Applington's statement. In fact, I would point to language in that document, the stipulation agreement, the second to last sentence on page 10 that says the one-time meter setup charge will apply only to customers who request to opt out after initial standard meter installation. So
I think the question is more focused on the expense. We heard testimony that a lot of the meter replacements that have been going on were instances where the company was out at the property already. So I'm almost reading this question to be more of, you're already out at the property, the current meter broke, and so you're going to replace it, and the customer at that point says, I don't want the ultrasonic, I don't want the new one. The company hasn't incurred additional expense, I think is the question. At that point, you could just swap it out because you're already there. So how does the settlement address that?
Yeah, Your Honor, I agree with staff counsel's assessment. I think in that instance, there would not be any additional incremental cost either to the company or to the customer because there had not yet been installation of standard metering equipment, which was then replaced by something else. So you have to have had a meter installed already and then have a different meter actually installed after that in order to incur the $100. So if we're in the middle of the process of a meter swap out and we hear from a customer that they want to opt out, that there would not have been a first and second installation and therefore no $100 setup would be due.
Thank you. That ends my questions on the July 30th stipulation. And I just want to
Your Honor.
wrap. Yes.
John Kleiser with the OPC.
Yes.
I don't want to add further confusion. I generally have been agreeing with most of what was said here. I just wanted to clarify a point. Is your understanding that customers would be able to opt out of the ultrasonic meters and retain a diaphragm meter? Because the opt-out provision addresses the AMI functionality of it, not necessarily, I think, the actual methodology of the meter itself, whether it's diaphragm or ultrasonic. I feel like there might be a point of confusion there.
That's on my end for not restating the correct jargon. My interest was in the additional expense, how that worked. If there was additional expense, my understanding from Ms. Eubank's testimony was it was at additional expense that would be recovered. So that if there wasn't, regardless of whether it was ultrasonic or AMR or diaphragm or an AMR device, that additional expense was my focus. Is that?
Yeah, that's fine. I wanted to make sure that the commission was not operating on the assumption that this provision was designed to allow customers to opt out of receiving a ultrasonic meter in favor of a diaphragm meter. It's exclusively related to the meter reading mechanism, as I understand it, unless opposing counsel wishes to speak up.
No, sir, I'm following.
That's correct, John. Thank you.
All right. I want to wrap up where we're at. real quickly. I am going to issue an order for responses on the propane storage questions. We have concluded our discussion of the July 23rd stipulation and the July 30th stipulation. Before I move on to the August 5th stipulation, I want to call one more time. We do have all of the commissioners participating today. And to unmute, it is *6 if you're on the phone. Are there any commissioner questions on the July 30th stipulation? Okay, hearing none.
Yes, Judge.
Yes, go ahead, Commissioner Coltmeyer.
Yes. I just had a question whether Spire used the propane storage during the February real cold spell.
Hello, Commissioners. This is Scott Weitzel of Spire. Spire did not use the propane facilities during the February polar vortex.
Okay, thank you.
Okay, let's move on to the August 5th non-unanimous stipulation and agreement.
Judge, before we move on, would you like staff, we did get those COVID-19 numbers for you, the AAO numbers broken apart by East and West. Would you like us to provide those now?
Yes, perfect timing.
Sorry to go back to the July 30th agreement. So this is in regards to the July 30th agreement. It's paragraph 3, where the total amount is referenced there. Based on staff's calculation, if the total amount broken apart by Spire East and West is as follows. So for Spire East, it's $2,115,294. For Spire West, the total is $4,116,015. Judge, I also think you asked what would the then amortization amount built into rates yearly be. So the total yearly amortization amount, which again is Spire East and West, is $1,246,202.
That was for East?
Nope, that is the total amount.
Oh, okay, thank you.
Sure. Broken apart for East and West is as follows. Spire East's amortization amount is $423,059. Spire West amortization is $823,203.
Thank you, Council. Okay, let's turn to our August 5th non-unanimous stipulation. Let's turn to Spire to start us off.
Thank you, Judge. May it please the Commission. The August 5th, 2021 non-unanimous stipulation and agreement represents a collective effort among the signatories to make improvements to the company's limited income program that would widen the net of availability of program funds to more customers and better assist eligible customers in paying down their arrearages. As part of this agreement, Spire has agreed to contribute $650,000 annually towards the Payment Partner Program using company funds. The company has also agreed to implement the Spire Critical Needs Pilot Program to better assist its customers with critical or medical needs. The agreement increases the overall funding amount for the low-income multifamily programs that we currently co-deliver and allows Spire to utilize rollover funding from fiscal year 21 to budget for the non-co-delivery low-income multifamily program, which broadens the outreach of the company's energy efficiency program to help more customers. The company believes that this agreement enhances stakeholder involvement in a manner designed to improve company programs and will ultimately inure to the benefit of Spire customers, particularly at a time when assistance is most needed. Here today to answer any questions the Commission may have regarding the agreement is Adrian Yates and Shaylin Dean. Thank you.
Thank you, Counselor. Let's turn to staff. Ms. Myers, did you already cover this in your general opening?
Yes, Judge. Staff does not have any specific comments to the remaining settlement agreements other than our general applicable comments. That said, I am here as well as some other staff members to answer any questions. Thank you.
Excellent. Any other parties wish to make a presentation on the August 5th settlement? Okay, hearing none, we'll turn to commissioner questions. Are there any commissioner questions regarding the August 5th stipulation? All right, hearing none, the judge does have a couple. On gross receipts tax, and I'm going to be looking at paragraph 6, which addresses the gross receipts tax. It states, quote, Spire will calculate the GRT, that stands for gross receipts tax, line item on customer bills in conformity with its tariff and applicable laws, end quote. Can the parties identify the specific tariff sheets where the gross receipts tax collection is explained?
I can, but you're going to have to give me a minute to look up what the numbers are again. So give me 1 second.
Okay, I'll move on to my next question and come back to Mr. Kleiser. Thank you for your assistance. Can Spire provide copies of the applicable laws that the parties are referring to in the stipulation? And I'm going back to that line that says Spire will calculate the gross receipts tax line item on customer bills in conformity with its tariff and applicable laws. So my question is, can Spire provide copies of those applicable laws?
So Judge, this is Matt Applington from Spire. There are a couple of different layers of authority, I think, when it comes to the citation to laws. So there's one or several GRT enabling statutes, which we can certainly provide the citation for. But what this is really intended to capture is the various ordinances that are enacted by each individual municipality taxing district as to how gross receipts tax should be calculated in that municipality specifically. We have several hundred at a minimum municipalities with different GRT ordinances. We could potentially pull all of those if that's something that the commission would be interested in reviewing, but it is a rather voluminous and time-consuming exercise.
Let's put a pin in that. What I'm going to do is go back and ask for some clarification if the request is for the statute numbers, but I think it's for the municipality enacted ordinances. If it is for the municipality ordinances, I will, either way, I will include whatever the outcome is in our order that we did for propane. Okay. Mr. Kleiser. Still working?
Yes, sorry. I can say that the sheet from the current effective tariff sheet for Spire, Missouri East is sheet number 14.
All right. We're going to go ahead and move on to the August 12th stipulation. Mr. Kleiser, are you ready, or did you want to take a minute?
I feel free to move on. I'll
Okay.
just jump in when I find the other one.
Sounds like a plan. We have now concluded our questions on the July 23rd, July 30th, and August 5th stipulations. This is our fourth and last stipulation that we'll hear a presentation on. This is the August 12th partial stipulation, and it covers two issues, pensions and OPEBs, and also property taxes. We'll start off, as we have been, with the company. Ms. Boxtra.
Thank you, Judge. Just briefly, the August 12, 2021 partial stipulation and agreement between Spire and staff resolves issues related to pensions, other post-employment benefits, or OPEBs, and property tax. This agreement includes a tracker for pensions and OPEBs that will allow incurred costs to be tracked and reconciled in future rate case proceedings. The company has Tim Crick available to answer any questions the Commission may have on this agreement. Thank you.
Thank you. And I will call for any other council that would like to make a presentation. All right, Mr. Weitzel, it looks like you wanted to say something? I'm sorry to call you out.
No, you're fine, Judge. You're correct. You could read me. For the west side, it's tariff sheet 14, back to the property tax.
Oh, excellent.
Yeah,
Thank you, sir.
GRT.
Excellent. Thank you, Mr. Kleiser. Thank you, Mr. Weitzel. We have heard our presentation on the August 12th stipulation. Again, and for the final time, I will call for commissioner questions. If you're on a phone, it is *6 to unmute. And again, we do have all 5 commissioners in attendance. Hearing no commissioner questions, the judge has one question. How is the settlement different from the current treatment of pensions and OPEBs? And I'll open that up to any other parties. I'll start off with a more detailed question. Is the company currently, and I'm sorry for the missing jargon, is the company abiding by the 80% requirement? Okay. And so that is continuing.
That's correct.
Okay.
Yes.
Okay, so would it be fair to say that the settlement is continuing the current treatment of pensions and OPEBs? Okay. I'm seeing nods of affirmation. Excellent. That concludes our on the record presentation. I have no other questions. The commissioners have no other questions. Are there any other issues? And to summarize, before I close this out, I'm going to issue an order in the next day or two directing responses on the propane storage questions and also whether or not the request is for Spire to provide the municipal ordinances in the GRT calculation question. Are there any other issues that the council would like to bring up now before we close out the hearing?
Your Honor, this is Dave Woodsmall for MECG. Not so much a question, but a request. I know you have information that you're waiting on so you can process all these stipulations, but my request is, to the extent that that gets done soon, I was hoping that we might be able to get the stipulations approved so that we don't have to brief those for September 7th. So
yes,
that was all I had.
Thank you. My intention is to hear from the commissioners and then proceed with all due speed.
Thank you so much.
I would anticipate looking for an approval within the next few weeks. And if we do get close to that deadline, I'll issue an order explaining that any settled issues would need to be briefed. We'll try and wrap this up before we get that far.
Thank you.
Absolutely. Hearing no other issues, we are off the record. The hearing is adjourned. Thank you, everyone. I appreciate you all being here.
Thank you, Judge.
Thank you, Judge.